of cases and judicial reform. Tendency of cases and judicial reform. Again, when we are discussing about the speedy justice, if you are giving or delivering or justice or a verdict after a long period, whether it will serve the purpose or not. What is the issues and challenges the formal delivery of justice administration system is facing? Who are all responsible, whether the judges alone, whether the lawyers, law teachers, as well as the general public as well? We have to think loudly for this. One of the aspects is whether the judge litigation ratio is, when we are comparing to other countries, is it okay? The second aspect, whether our system is few lawyering center, that may be the reason or not. Again, we are thinking on it whether our formal system is giving lot of delay. We have, for facing that challenges, we have introduced some alternative methods to tackle that as formal aspect. We start from arbitration, mediation, conciliation, judicial settlement, amicable settlement, etc. Again, in the alternative the system, arbitration, whether arbitration again taking a long way to settle that issue. These are the one side. Second one, the mindset of the stakeholders in this system is tackling this issue or not. Where we can find the actual cause for that. Is it the criminal justice system or civil justice system? When we are going through the statistics, we can find 3 years to 15 years in the civil minimum. Criminal justice system is not also like that. We have lots of Supreme Court judgment and common cause case and all. Now, I think now the speakers will find out and narrate the status where we are standing today, how we go about for tomorrow. With this small introduction, I request Dr. Meera Baryok, lecturer, Delhi faculty and editor, the Witness magazine, to share her views with us.
I welcome you all. First of all, I have just now come to know that a few of you are here by chance, not by choice. Because you were expecting a session on banking law. So, although I am not responsible, but still I apologize. Another thing is, before I start with my paper, I would like to share with you one thing. I don't know how many of you might have read the novel by George Orwell, Animal Farm. And the basic idea of the book is that the lesser the laws, the lesser will be the litigation, the lesser will be the litigation, the lesser will be the delays. Wherein he says that there was a man who had in his farm many animals. So all the animals decided that life is not going so well, so let's enact a law. And they enacted a law that those creatures who have 2 legs are unequal to creatures with 4 legs. That means in a way they had aligned man out of it. Thereafter, after a few days, they came out with a resolution that all the 4-legged animals are equal but pigs are more equal. After a few more days, they came out with a resolution. All pigs are equal, but some pigs are more equal. So the more you complicate the thing, the more the laws you enact, the more the number of litigation and more is the penalty. That's the way I read the novel. I may be wrong, but I suppose probably the main key to reducing the litigation is reduce the number of laws. Now today I am going to present a paper on online dispute resolution. Online dispute resolution has not been in vogue. It is at its evolving stage. I have picked up a few information from here and there and presented a paper. It may be lacking in many details, but I suppose it offers a good resolution. It offers a good solution to resolving disputes. More so when more transactions are being carried on through e-commerce. E-commerce means, basically two ways we are more nowadays interacting with internet for business. One is we find a product which is available to us online and we want to purchase it. So online shopping. So if we order for something, we receive something, the fact is it does not match the quality or the description which it gives in the site. Now how do we go and how do we file a claim against the person who has sent those goods to us? It is very difficult. Another possibility is buyer is in India, the seller is in America. Both of them enter into a contract, and whatever are the normal causes of dispute over a contract, besides that there may be certain more problems because of communicating through internet. Suppose if I place an order through mail, the other person may say I had replied to your mail, but you did not receive it. I may revoke my offer, but he may say that no, the offer was a lie. So that kind of problems may emerge. Third possibility is all of us are net savvy nowadays. We are downloading the software of various companies. At times, due to operation failures, it does happen that all data gets transferred to their site. And so whatever was my data is available to people at large. That means it is interfering with my right to privacy. In such a case, there are efforts going on that there should be online dispute resolution available. My paper focuses on that. I have just presented the 3 alternate modes of online dispute resolution. I will be very frank to you, it is at evolving stage. Whenever any law is enacted, all of you are aware that lot of discussions are held, opinions are invited. Thereafter, after a long discussion, ultimately the law is enacted. So whatever I am discussing over here may be suffering from many lacunae, but I am suggesting another alternate model, alternate dispute resolution, but I would rather call it online dispute resolution, that is ODR. Online dispute resolution, first of all, essential. All of us are aware that even that arbitration, conciliation, mediation, none of them can take place in regard to subject matters which are not arbitrable. So that would apply to online dispute resolution also. For example, winding up of a company. Winding up of a company cannot be ordered by arbitrator. So when it cannot be ordered by arbitrator, obviously it cannot be ordered by online dispute resolution method. So first of all, one has to make sure that whatever matter is being submitted for arbitration, it should be a matter which is arbitrable. Second is, the rules of the body chosen to settle the dispute need to be verified to ensure that they are not restricted to one particular type of player, that is business or consumers. So whenever we opt for online dispute resolution, we have to decide which country's substantive law and which country's procedural law will prevail. Otherwise, there would be conflict of laws. So instead of resolving the dispute, there would be generation of more disputes. Further, the mode of dispute resolution should always be specified to define the obligations of the parties and should lay down the sanctions for non-fulfillment of those obligations. All of you who are sitting over here, I hope you are aware of the fact that mediation, conciliation are different from arbitration in the First of all, mediator, he is not an adjudicating authority, he is only a facilitator. He just makes sure that the parties keep on negotiating. He cannot suggest any solution. So he is not actually an adjudicating authority. As regards conciliation, conciliator derives the authority only because parties ask him to reconcile their matter. And in case the decision given by the conciliator is not acceptable to them, conciliator cannot pass any binding award. Only and only if the parties reach a settlement agreement, the award is binding. But in case of arbitration, once you submit that dispute to the arbitration, you have to be circumspect that the person you are choosing as an arbitrator has to be impartial, independent, having the skills which can deal with your dispute, and it should be clear which country's law would he follow in case it is a dispute of international character. So, online dispute resolution method also, online mediation and online conciliation are better modes of resolution because online arbitration may find difficult. It will be difficult for the online arbitral award to be enforced. Again, probably because of the problems of jurisdiction. So, in case the parties opt for online arbitration resolution, then they have to be sure that it has to be enforced and there should be sufficient protection or sufficient covenant in their agreement. Online mediation and conciliation in matters not essentially involving any sum of money or where the sum was justified, the computer is not acceptable to parties. Information technology has led to evolution of only online mediation and conciliation techniques. Mediation or conciliation techniques are more helpful in case of disputes involving provider and consumer. The conciliation or mediation body tries to bring the conflicting parties together so that they can arrive at an agreement which is then formalized in a settlement agreement. While the mediator or conciliator does play an active role, he or she cannot impose an agreement or a decision on the parties. This impediment or facility, depending on how one views it, exists in case of mediation and conciliation techniques otherwise also. No conciliator or mediator can impose his decisions on either party, and the only acceptable solution is by way of settlement agreement. Online arbitration, this has been now made available by a few arbitral institutions. They provide for a partially or totally electronic procedure. More so in case of contractual disputes involving business deals. Information technology also provides for arbitral procedures where the dispute is resolved through assistance of arbitrator. The internet makes possible the remote administration of arbitral procedures. It does not require the presence of the party or the legal representative. For example, if a party to a contract complains about the non-performance of the contract, the adjudicator merely has to confirm non-performance from the other party. Another way of, probably you must be aware of, lately there was a litigation initiative by Advocate Arun Jaitley, that is domain name. It is being sold on as a domain name which was not given to him but being auctioned. So he has obtained an injunction from the court. So another new category is one more type of online dispute resolution which helps resolve disputes of cyber squatting. Cyber squatting is a situation where owners of trademarks are unable to register their domain names because some other operators might have registered those names in bad faith. Agreed parties can refer the matter by electronic means to one of the organizations approved by Internet Corporation for assigned names and numbers for having the disputed domain name transferred or deleted. In disputes relating to registration of domain names, the panel members only have to confirm that the claimant is the owner of the trademark and that the respondent made a bad faith registration. Now, what are the advantages of online dispute resolution? In online dispute resolution, the parties have to bear the operating cost, which is too small compared to costs involved in a normal litigation. Online dispute resolution, like other ADR, reduces the cost of dispute resolution, and it is preferred for confidentiality and enforceability of awards and to rule out the uncertainties in the choice of adjudicator